information charging sexual battery in counts 1 and 2 and false imprisonment in count 3. Count 1 alleged the violation of sexual battery by vaginal penetration. Count 2 was sexual battery by anal penetration, and count 3, as I said, was false imprisonment. The case proceeded after some delay in logistics and proceeded to trial in April of 2005, and the verdict was rendered on April 21st, about 12:40 in the morning, where Mr. Morales was acquitted of counts 1 and 3, acquitted of the sexual battery by vaginal penetration allegation and of the false imprisonment allegation, but was found guilty of count 2, which is the sexual battery by anal penetration allegation. The appropriate post-trial motions were made, and a motion for new trial was filed, and there was no argument heard. It was denied the day after it was filed, and then in due course the defendant perfected his notice of appeal and seeks appellate review before this court. The primary allegation that is the basis for the appeal is the wrongful denial of the motion for new trial and the component aspects of the legal issues framed within that. And that is that the court didn't, and we submit, did not appropriately weigh the evidence or the credibility of witnesses. It is difficult to say what the court did because the motion was denied without argument or without any further edification from the court. Certainly, the standard for determination is abuse of discretion, as this court has said on several different occasions. And we submitted that there are certain things that would, if you looked at the salient highlights of the testimony in the case, would indicate that the court would have abused its discretion by not properly weighing the evidence. The factual circumstance of the case is important to understand the issues as they arose during the trial. That's how the case got to this court. It was a situation that is somewhat unique, I would submit, because the victim and the defendant were engaged to be married at the time of the alleged assault. That was a relationship that had spanned about 16 months and had been in two different times or parts. There was part 1 in September of 2002, and then they finally they met on the internet. They exchanged messages that way, and then finally some photographs, and then finally met each other at Ms. Bagwell, who was the victim, at her parents' home in February of 2003. The nature of the contact was fairly frequent, 4 to 5 times a week, and there was, according to Mr. Morales, some intimate sexual contact, but no sexual intercourse either in part 1 or part 2, but intimate sexual contact. The relationship was broken off by the victim in May of 2003 because Ms. Bagwell indicated that she had just come out of another relationship, a prior fiance, Steve Sanders, and that she did not wish to get married that quickly or engaged, and she said that the defendant was desirous of doing so, so she broke off the relationship. Subsequently, they got back together, and she did some internet work for him, and then the relationship picked back up again, and then in December of 2004, the defendant asked for her hand in marriage, which is what she had asked him to do by going to her parents and in a traditional way to do that. There was the exchange of an engagement ring, fairly expensive, of slightly over $8,000. And then when they became engaged on February 6th of 2004, that they then proceeded to join the same church, First Baptist Church of Windermere, and then also proceeded to enroll in and attend premarital classes. That was a 13-session premarital course. They had attended 12 of those by the time the incident that's complained of occurred. The last or 13th session was the next day, had they gone to it. And the nature of the contact, again, was 4 to 5 times a week, with telephone calls and emails, and also intimate sexual contact. And one other thing that needs to be explained is that her parents had done some research on the internet and had, through the iClerk in Orange County, had discovered Mr. Morales' name in an injunction proceeding for domestic violence. Obtained a copy of that file, and because there had been an allegation of a sexual battery by a lady by the name of Figueroa, and at that time she obtained an injunction for protection against domestic violence, but it also referenced the criminal arrest, sexual battery. No information was ever filed, no charges were ever filed, and the case was expunged. However, the expungement was not complete, and there was still reference in the injunction papers to that. With that information, then Ms. Bagwell's parents and Ms. Bagwell summoned Mr. Morales to their home for a meeting and asked that he explain this and other matters, asking to bring a litany of materials, financial records, evidence of schooling, and also some issue regarding the fact that he had previously fathered a child born out of wedlock. In fact, he had fathered 2. Neither party has ever been married, and both were single at the time of this incident, and at the time of trial, Mr. Morales was 35 and Ms. Bagwell was 26. And both are college educated, and Mr. Morales had done some coursework on his master's degree. And so they have this meeting. He answers their questions, and then Ms. Bagwell indicates that she is satisfied with the explanation, desires to go forward with the plans to be engaged and ultimately to be married. This meeting was January 19th. On February 6th, they become engaged, exchanged, he gave her the ring. They went away for the weekend to St. Augustine, came back, then there's an engagement party. They're still going to these premarital meetings, etc. At trial, Ms. Bagwell testified that she thought that Mr. Morales truly loved her, and she testified that she truly loved him and was looking forward to being Mrs. Morales. And an actual date had been set in December of '04, but was later changed to the summer of the following year. And so it was in that context that the issue is joined as to whether or not there was any problem with the relationship. Ms. Bagwell indicated on the night in question they went to see the movie Troy, a rather long movie, and she expressed some doubts or concerns that she had with the relationship. But ultimately, after they discussed it, she said in her handwritten statement that was received in evidence that everything was fine. And so they go back to his office and engage in some of the same type of contact that they had done on prior occasions, intimate contact without penetration. There was a rape exam by Lourdes Burke and an ARNP, advanced nurse practitioner, and in that exam there was no spermatozoa on the vaginal swab, and there was spermatozoa on what was the anal swab. One of the big issues in that regard was that Ms. Burke could not say whether or not she used an anoscope or not. The anoscope is used to preserve the integrity of the specimen that's obtained from the rectum. And obviously, if there is any semen in the anal area and a Q-tip is used, then that can be contaminated or come in contact with the Q-tip, and it would give the erroneous impression that that semen was from the rectum rather than from the anus. And the testimony was that he had that she had semen running down her legs, and he went and obtained a shirt and cleaned her up, and then they ultimately left. So at trial, I think the biggest point on count 2 was the equivocal nature of the evidence regarding the anal exam, because Ms. Burke set up what we say in our brief as a catch-22 situation, that she customarily does certain things so she doesn't list them. And then when you ask her if she, how would she know if she did something that she didn't list, and then she just didn't really have an answer for it. In other words, she was asked directly, did you use an anoscope? She said she did not recall, could not say whether she did or did not. She then said, however, she could make sure that from now on she would note it. But she also indicated that if a person cannot tolerate the anoscope, that she would use the Q-tip. But that likewise wouldn't be noted because if the anoscope is customary and you use the Q-tip, you'll never know because she made no note of it. Also, she indicated that it was possible that if she used a Q-tip and there was semen in the anal area, that semen could be removed by coming in contact with the Q-tip, and hence would be what would amount to a false positive, because it would not be penetration, it would just be semen in the anal area. And the allegation and the information was penetration and not contact. Also, she testified that in people that have a lot of anal sex, the sphincter muscles are relaxed, but she did not see that in Ms. Bagwell, and because of that, she expected to see a presence of blood, and she did not see any. And so those were, I think, the salient highlights of the evidence that would have indicated that sitting as a 13th or an extra juror, make that a 7th, and reviewing the evidence and the weight of the evidence, that a new trial would have been appropriate. Also, it needs to be understood that the biggest, another major problem in the case was the state's intention to use similar fact evidence, and they gave
So you're down to 2.5 minutes. Do you want to reserve? Do you want to press on? Up to you.
I'd like to reserve a little if I could.
All right.
Thank you.
May it please the court, my name is Bonnie Parrish, and I represent the state of Florida in this case. It's the state's position that the motion for new trial was properly denied. As to the weight of the evidence, a review of the evidence shows that there was more than a manifest weight of evidence that the sexual battery occurred in this case. I don't know if you want me to go ahead on to the other issues that weren't discussed. If you have questions about those other issues.
What about the issue that was raised concerning the prohibition of cross-examination concerning the victim's statement, based on her religious beliefs that she did not engage in premarital sex?
Okay. Just the argument about that it opened the door, or the whole thing, the motion, and
she testified to that, and I understand the rape shield law and that sort of thing. But apparently, she opened the door and she testified that basically I don't believe in premarital sex, and I think she testified as a premise that was based on religious beliefs, and they wanted to cross-examine to bring out the fact that she had engaged in premarital sex with her prior fiancé, and they were prohibited from doing that.
If you read the whole direct, not just the one, the specific statement that they refer to is, she's asked specifically, what views do you have on sex and marriage? And her answer was, I would not have sex before marriage. Mm-hmm. Before that, she was asked if she had had sexual intercourse with Ms. Morales at all during any part of their relationship, and her answer was no. Then the prosecutor asked, had you talked to Mr. Morales during that time about your traditional beliefs? And she said, yes, I did from day one. And then the question is specifically, what views do you have on sex and marriage? And she answered, I would not have sex before marriage. I don't believe that opened the door for anything. I think that was in reference to what she talked about with Mr. Morales.
Yeah, I think the trial judge, may have viewed it that way, but you can also view it in the context that, that this was an innocent victim that didn't believe in premarital intercourse, and as a result, she didn't consent at this particular time. And consent was an issue, wasn't it? And why didn't they have the opportunity or the right to cross-examine her to show the jury that, that's not true based on prior activity with her fiancé?
Well, consent was not the whole defense in this case. It
was one of them,
consent,
wasn't
but there was no penetration. That no sexual battery had occurred. He never penetrated.
Was consent an issue at all in the case?
As to the penetration, yes, it was. I would argue that it doesn't matter. The rape shield law still would preclude this from coming in. It's not relevant.
Well, wait a minute. Now, you're telling me that the rape shield law precludes it from coming in, but that gives the state the license to put the victim on the stand and produce all of this testimony to the jury, and they have no right to cross-examine on it? That can't be right.
I would disagree with your interpretation of that. I don't believe they put all this testimony on. What she was testifying to was her relationship with the defendant. That's what she was testifying about. That she had told him she didn't want to have sex before marriage. She testified what she did compromise and agree to do. I don't believe you can take that out and say.
Let me ask the question again. Based on the rape shield law, if the state opens the door to that which is prohibited by the rape shield law, are you telling me that they're still prohibited from cross-examination on that issue?
I think they still have to show how it would come, if it could come in under the rape shield law.
So, in other words, you're telling me that based on the rape shield law that the state has the right to put on evidence that would otherwise be prohibited by the rape shield law, and they have no right to cross-examine on that evidence. Is that what you're telling me?
I'm not telling you that. I'm telling you that the judge initially went through their motion and found under the rape shield law that it could not come in. When this occurred during the trial, she again went back through it again to see if it met the exceptions that the rape shield law provides, and she found that it didn't. It's the same issue because it deals with rape shield.
So you're saying that the testimony that the victim did not engage in premarital intercourse as a basis of religious beliefs.
That's not what she testified.
Well, didn't she testify that she did not believe in premarital intercourse?
The prosecutor asked her, had you talked to Mr. Morales during that time about your traditional beliefs?
Her traditional beliefs.
And she said, yes, I did from day one. Specifically, what views do you have on sex and marriage? I would not have sex before marriage.
So she tells the jury, I would not have sex before marriage. Consent is an issue, and they don't have the right to cross-examine on that issue because the rape shield law prevents that type of evidence from coming in, but allows you to present it anyway, and in essence deprives them of the right to cross-examine. That doesn't make any sense.
Deprive them of his right to cross-examine.
Well, they asked permission to present a very brief question to the witness and solicit the fact that she had engaged in premarital intercourse with her prior fiancé, and they were prohibited from doing that.
Yes, they were. It was completely irrelevant to this case.
Well, once she brought it out and consent was an issue, that made it relevant, didn't it?
I would disagree with you that she brought it out. I disagree with you on that. I think she's not talking about for always and forever I've had this belief. She's they're asking specifically about the defendant. And she says that's what her belief was. That's what she told him. She never stood up there and said she was, the Queen Virgin and had never had sex with anybody. Maybe in that case, maybe it would come in. I think it's completely irrelevant to anything whether she had sex 2 times with the prior fiancé. Completely irrelevant. It doesn't, it establishes nothing. And in fact, in my personal opinion, I was a prosecutor.
Let's just assume for purposes of argument that it was an error.
Okay.
And that the trial judge should have allowed them the opportunity to cross-examine. Then where does the analysis go?
Harmless error.
Harmless error, right.
Clearly was harmless in this case. This was not your classic sex battery, he said, she said case. There was physical evidence. There were lacerations around the anus. The defendant's testimony was basically that, he didn't go beyond her buttocks, and that's where the ejaculate went, but yet semen is found on her anus. She has lacerations there. At the vaginal opening, there's a laceration. It clearly would be harmless in this case. If you have no further questions, I'll rely on my brief and ask if you affirm the conviction.
Thank you, counsel.
Please, the court.
Why isn't it harmless? Why isn't it harmless error? If we say it was error, why isn't it harmless error?
No, I don't believe that we could say that it's harmless error because it goes to the essence of credibility, and her credibility was one of the dominant themes of the prosecution. And it also is allowing the state to accredit their own witness. The question and the answer was put in very adroitly, I have to admit, because it then puts together religious belief and a generic statement. It wasn't confined to, and I told him, Mr. Morales, that I would never have sex before marriage. And it's a misstatement. It's a factual assertion. It's not true. And I think that that's what opening the door concept means, as explained in the Robertson versus State, the Florida Supreme Court. Recently, this court in the Daquel case on one comment where the lady said, "Why did you allow this married man in your room to sleep in your bed?" She said, "Well, I didn't think that a married man was a threat." Whereas the night before, the proffer was she had had sexual relations with a married man the night before. Certainly that was relevant. That was a he said, she said, no other type of evidence. But here, when credibility is such a central issue, it does allow the admissibility of evidence that would otherwise have, if it had been inadmissible, if it didn't fall within the exception of the rape shield law, it does allow it to come in to explain, clarify, and give the defendant the full benefit of a meaningful cross-examination. And to say it's harmless error, I think is just one way to try to obviate a problem that the state has that they just can't get around.
Let me ask you, the question was specifically what views do you have, which indicates present tense, on sex and marriage? Was there any across or any proffer of across of whether the views have changed?
No, sir. The proffer that was asked of the court, what would you say that was very narrow in scope, and that was that what you just said, that's not true, basically is what it amounted to, that you've had sexual relations before, after she said I would not have sex before marriage.
Counsel, you've exhausted your time. Thank you.
Thank you.